This group Beyond Binaries, and of course to Mohammed Siddiq for organizing this and for inviting me to this very interesting and important panel. And Uniform Civil Code. Now this, as probably Siddiq indicated, Siddiq or Siddiqi?
Siddiqui.
Siddiqi. Oh, sorry. Okay, as Siddiq, my earlier study was Siddiqi. So Uniform Civil Code, as I think he indicated, has been a contentious issue in India for decades. And it has been a contested concept ever since K. Munshi first raised it in the Constituent Assembly, and to this day, 75 years later, opinion remains divided on this issue. And I think there are two or three questions that are at the heart of this debate. One is whether religion-based personal law should be continued or a UCC should be instituted. Now, some of these questions have come to the forefront. They sort of come to the forefront every now and then, and they have been at the center of debate ever since the Uttarakhand government in January of this year. The Uttarakhand legislature passed this bill. Now there is agreement that religious personal laws are discriminatory. I think that we would all agree with, and that they must change. But there are serious disagreements about how this change should come about and how to achieve personal law or legal reform. And very importantly, I think, there is disagreement about whether such a code should be a uniform civil code or gender-just civil code, or, as some might want, simply a Hindu code which is based on the Hindu Code Bill. Now, if we look at the post-independence trajectory of legal reform and Uniform Civil Code, I think it is embodied in three key moments. The Shabano case in 1986, the abolition of triple talaq in 2019, and the Uttarakhand UCC in 2024, but passed in January 2025, introduced in 2024 and passed in January of this year. Now, if we look at these three key moments, it's a combination of progress and regress. Progress as far as triple talaq is concerned, regress as far as the reversal of the Shabano judgment is concerned. As far as the third development in this, which is what we are discussing today, the UCC, we can only discuss it in the abstract because we really don't know what a UCC involves. But the point is that there has been a long fight for gender justice, starting in 1978, when Shabano, then a 62-year-old woman, filed a petition in the Supreme Court demanding maintenance from her husband for pronouncing a triple talaq. Now, the important thing is that the Supreme Court gave a landmark judgment granting maintenance to her to be paid by her husband under the Criminal Procedure Code, and the Supreme Court very rightly argued that Section 125 of the CRPC overrides personal law. So in that sense, it was a very radical judgment, and that the criminal code as against civil law applies to everyone, including Muslim women. But as I'm sure, of course, most of you are so very young, and wonderful to see so many young people, and you wouldn't know that this was a really, as I said, a historic judgment, but at the same time, it raised a huge political uproar by the Muslim leadership, political leadership, but above all, the clerical leadership of the Muslim community. So much so, the uproar was so great that the then Prime Minister, Rajiv Gandhi's government, pacified this uproar by reversing this judgment, and that was a retrograde step. It was an absolutely retrograde step to have reversed that judgment, and it was really the first move towards legal reform. And so the Muslim Women Protection of Rights and Divorce Act 1986 was introduced to override this judgment, and then once again Muslim women were excluded from the purview of the CRPC. Now, triple talaq, the second moment in this story, is of course, I think again all of us present here would agree that triple talaq is a practice, it's an abhorrent practice, and an abhorrent practice that many Muslim men employ to divorce their wives instantaneously by simply uttering the word talaq twice. So it is certainly very and it is certainly oppressive and anti-women by any standard. And what is more, as again most of you would know, that it has been abolished in most Muslim countries, but that was not so in India. And the Supreme Court again, just as in the Shah Banu case, I think took again a very positive step by declaring triple talaq invalid. But the government of the day was not satisfied with the Supreme Court invalidating it. It went ahead and went ahead and passed a law to abolish it. So in July 2019, this was legislatively abolished. Now, this, as I said, is a progressive step as against the Muslim Women's Act of 1986. But this progressive step has provoked mixed reactions, in the sense that this new law with regard to triple talaq has also proved to be controversial because it criminalized this practice rather than simply confirming that divorce pronounced in this way is invalid. Now, this then brings me to the third, which is what we are concerned with, and I'm sure my colleagues and friends here will have much to say on, especially Brenda Grover, who is a lawyer, is dealing with this in the Supreme Court. Now, the UCC simply, what is the UCC? At least in theory, it entails the legal unification of civil codes of different religious communities, and enforcing a uniform code in matters of marriage, property, inheritance, and adoption. But again, the Muslim political leadership and religious leadership in particular, and the Muslim Personal Law Board, is vocally opposed to a uniform code, insisting, and I think wrongly, but again I will refer to Brenda Grover's assessment of this. I think they're wrongly insisting that personal laws are an intrinsic part of their religion, and therefore the state cannot legislate on it. But in between this are many others, and I think that's really speaking the majority, who believe that uniform laws are desirable, but that as a country we are not quite ready for it, and perhaps less so at this juncture when a majoritarian government is in power. But in contrast to the Muslim leadership, just as the Muslim leadership is the religious leadership and also sections of the political leadership are vehemently opposed to it, the BJP and the Hindu right is equally vehemently in favor of UCC and have been pushing for it. And I think their point is not so much that they are so concerned about women's rights or women's equality or gender equality and the need for legal reform. I think they are critical. They are primarily making the point, and they're extremely critical of the unequal exercise of state power, which has intervened to reform Hindu personal laws, whereas the same was not done in relation to Muslim personal law, of course completely forgetting their own, that is the Hindu rights, trenchant opposition to the Hindu Code Bill in the 1950s, which is why I'm sure most of you are students of society and politics are aware that the Hindu Code Bill took a long time to be passed, and it came in stages. It led to the resignation of then Minister Dr. B.R. Ambedkar, and it was, as I said, it was, there were lots of issues, but the bulk of the opposition had come from Hindu conservatives inside the Congress and outside the Congress, led by the then Hindu right, then not BJP, but groups of that kind of thinking. So nonetheless, I think for the Hindu right, leaving Muslim law untouched implies unequal and asymmetrical treatment. And this asymmetry has formed the basis of their charge that of their whole criticism of secularism, of secular politics, of secular parties, declaring them to be pseudo-secular, because they think not pushing for a uniform civil code is tantamount to Muslim appeasement, and that this is being done simply for reasons of vote bank politics and so on. Now, of course, it is true that secular governments have not really made any attempt to introduce a UCC, but neither has this government. This government, that is to say, the present government, has been in power for now nearly 11 years, and they have not brought forward even a draft UCC, leave alone introducing, a full-fledged UCC during the past 11 years, despite enjoying an absolute majority. Whereas governments before the BJP came to power in 2014 for almost 30 years, and again, many of you as students of politics would know, were coalition governments. And but therefore, it was that much more difficult for them to take this kind of radical step. But here we have a government which until last year had 303. That is, just the ruling party had 303 members of parliament, and yet they have not really introduced a UCC, and different state governments therefore have chosen to introduce it. And we have the Uttarakhand legislature passing this bill. But I want to make three quick points, because I think Brinda will probably speak on it with greater authority than me, and that is what I found while reading for this talk. I think there are three things which struck me as significant, and I'm sure we'll hear more on that. And one is that it's supposed to be a uniform code, but it does not extend to tribal groups. If indeed this is a law for women's equal rights, why should women of any community be left out? So clearly, and I think the point that that Siddiqui was making quite well, I think, is that this uniformity is targeted at some. It is uniform only for some groups who must fall in line, but not for others. Then there are two other crucial issues, I think, which need to be noted, which I found really very, when it was introduced on January 24, is the issue, what can be called as extraterritoriality, and the other, of course, is the well-known issue, which is that it invades privacy. So the extraterritoriality issue I found really quite interesting, because this is an issue which is supposed to apply. The Uttarakhand UCC is supposed to apply to all Uttarakhandis across the country. So its application is not confined to those who are resident in Uttarakhand, but it will apply to everyone regardless of where they live. Now, how is that to be established? This obviously entails some amount of surveillance on the part of the government. So in a broad sense, it covers not just those who are domiciled in the state, but even those who have lived in the state temporarily, and even central government employees who may be posted there, who may be on deputation to Dehradun or to Uttarakhand. It will apply to them. But why should those who are temporarily residing in Uttarakhand be subjected to a law when they will be leaving the state maybe in 2 years, 4 years. I mean, there will be many students who would be studying there in their various technical institutions and so on. Now, will it apply to them as well? So there is a certain inherent absurdity in this law. And the second, of course, a point which has been under much discussion ever since this was passed, and that it reflects a disdain for individual choice and liberty, and that it and especially problematic is the portion aiming to formalize live-in relationships through registration, and that, of course, has been challenged by a live-in couple in currently residing in Uttarakhand. I don't know whether they are Uttarakhandis or that they happen to be residing there because they are working there. So I think at the heart of this whole issue, if we look at the UCC issue from the lens of the Uttarakhand UCC, I think is that the main problem with this whole UCC debate from the beginning has been its emphasis on uniformity. While the UCC is desirable and a progressive goal for a secular country, I think the concept of justice or gender justice should not be lost sight of in the search for uniformity. In fact, I think uniformity should be an incidental consequence of equality. And the focus really, the most important issue really is that there should be no discrimination against women and no exceptions in this case, as the Uttarakhand law is doing. So I think the need for personal law reform is indisputable. But unfortunately, this larger project of legal reform has made no significant progress in the last 77 years since independence. And I think one of the problems is that this whole legal reform project from the very beginning has been entangled with minority rights. And this entanglement is much greater in the present conjuncture, which is dominated by majoritarian politics. And therefore, I would submit that it is, but at the same time, even I would submit, even though I am a votary of legal reform, I would also say that it is difficult to isolate legal reform from the Muslim condition in India today, which is marked by discrimination and exclusion from the economy, from polity, from society. Now, it is this which has complicated the pursuit of gender justice, even though I think we all agree that this is extremely important, but at the same time, I think we can't really, an excessive focus on personal laws glosses, and there is an excessive focus when it comes to Muslims on personal laws by those who are not Muslim. Muslims themselves don't want any discussion on it, but non-Muslims are completely focused on that. And that glosses over the larger economic, political and social problems that define the everyday experience of Muslim women. While a UCC and legal reform is desirable, but it's surely not a panacea for the problems Muslim women face. And they suffer from discrimination in different spheres. Their socio-economic status is dismal. There's abundant evidence that they rank below the national average when it comes to literacy, schooling, and workforce participation, especially the last of the three that I have mentioned. And it's clear that their deprivation does not come from the absence of legal reform. Their deprivation stems from a shortage of three essentials. Knowledge, measured by literacy and average years of schooling, not to speak of college and university. Economic power, work and income, in short supply of course, and autonomy measured by decision-making and physical mobility. And gender discrimination that they face coalesces with class inequalities and pervasive social hierarchies which compound their marginalization. And we must not forget that they're conspicuous, that is, Muslim women are conspicuous by their absence in the world of politics, bureaucracy, universities, and the public and private sectors. But the interesting thing is, even as we speak, Muslim women's groups have emerged in the past 10 or 15 years. And they have a voice which they did not have earlier. And they have emerged as an important voice, especially in the campaign against the Citizenship Amendment Act. And I want to really emphasize that, because for the first time, Muslim women came out on the streets, not in an identity issue. And I think that's very important. They came out to promote equal citizenship, rights pertaining to all fundamental rights guaranteed by the Constitution, and not just those concerning personal laws. And I think that's something that we must keep right in front as we think about it. And let me just conclude then by saying that I think we're having a discussion which is wonderful on the Uniform Civil Code, but I'm not sure what we are discussing, because so far all we know is that there is a large group of that there are some parties which are very keen, political parties which are very keen on a Uniform Civil Code, but we know very little about it. And after the Uttarakhand government promulgated the UCC, now we heard after that Gujarat, then Uttar Pradesh, Madhya Pradesh, and Assam have also moved for similar laws, and they have set up committees and so on to work on this. But so far, none of these governments, which seem to be very keen to introduce a code, have actually presented a draft. But I think there's a more important issue. Again, I'd like a legal opinion, like to hear a legal opinion on this, and that is that can state governments have their own civil codes? I mean, aren't different state-based civil codes antithetical to the very idea of a uniform civil code, which is rational? And here we are going to have, we have one government, of course we have Goa and we have Uttarakhand, and possibly another 4 state governments introducing it. So the question really is for the courts is whether individual states can do so, and whether this is a subversion of the Constitution in many ways. And this is because the text of a proposed UCC is nowhere in sight. The Law Commission, which should be presenting us with a draft, has not presented or circulated a draft. Indeed, the previous Law Commission examined this issue and in fact came to the conclusion that a UCC is neither desirable nor necessary. In fact, it highlighted the importance of pluralism and the guarantees of pluralism in our Constitution. And instead, the previous Law Commission had suggested that each body of personal laws be reformed to eliminate discrimination and regressive practices. However, the present Law Commission has taken a different view, and they revived the idea and started gathering views from the public on a UCC, but without any blueprint for it. I ask you, how do we give opinions when we don't know what we are supposed to give opinions on? So at this stage, we do not even know whether a UCC will apply to all parts of the country and to different communities, notably to the Northeast. Will it apply to the scheduled castes and scheduled tribes? The reason I raise this question, and again I will defer to legal opinion on this, is that the constitutionally guaranteed special protection to states such as Nagaland, Manipur, and the northeastern states. Their special status will have to be abolished once a uniform civil code is enacted. Also, what happens to the Hindu undivided families, HUFs, in terms of income tax and so on? Will that be stopped once there is a once there is a unified code. Now, it is hard to see, and I conclude with this point, it is hard to see that any regime, least of all the present regime, would be willing to adopt a UCC or such a course that would antagonize powerful groups in the Northeast, the HUF, which means very large numbers of people in the Hindu community. One thing is clear, and I think I end with the point that Siddiqui started with, and that should be clear from what I have stated in the last few minutes, that this is not an issue concerning the Muslim community alone, far from it. It will affect the rights of many groups. Hence, the challenges confronting gender equality in India are many and immense, and ironically, there are many hurdles confronting the project of uniformity, which is what the Uniform Civil Code is all about. Thank you.